Welcome to Access Point. Access Point is a new on-demand business education tool being developed for use by small businesses across the District of Columbia. Access Point is brought to you by the DC Department of Housing and Community Development, DHCD, the DC Department of Small and Local Business Development, DSLBD, District Bridges, and the Rhode Island Avenue Main Street.
Greetings, everyone. Welcome to the DC Bar Pro Bono Center's webinar, Commercial Leasing Issues During a Pandemic, brought to you in partnership with Rome and the DC Small Business Development Center Network. I'm Darryl Maxwell, an Assistant Director at the DC Bar Pro Bono Center. Before we get started, I'd like to thank a few people. First, I'd like to thank Lauren Paley and Christine Kulamani of the Pro Bono Center for all their help making this webinar happen and making this possible. Next, I'd like to give a huge thank you to our friends at Rome. In particular, our presenter today, Ross Coe, who's an associate with Rome, who has been a long-time small business clinic volunteer. He was extremely happy to step forward on this project and present this really timely information. One last note of thanks go to our friends at the DC Small Business Development Center Network, specifically to Charles Mott and Felipe Perez for co-sponsoring this program. Before we get started, I'd like to go over a few logistics for today's webinar. The webinar will be recorded. For those of you looking, there is a section in the dashboard called Handouts. That's where a PDF copy of the handouts for the presentation will be. During the presentation, I will share questions with our presenter. You can find the question box also in the dashboard. With that, I'd like to make sure to mention, in these extremely dangerous and unsure times, businesses of all types are uncertain whether they will reopen soon, how social distancing rules will apply, and whether they can withstand the financial impact of this downturn. Many of you have questions about what your rights are going to be as tenants, what options your landlords have if rent is late, possibly whether a landlord's forbearance from their bank can impact your rental payment. Ross Coe, as I mentioned, will lead our discussion today to try to find you some answers. Ross, thanks so much. I will turn it over to you.
Thanks, Darryl. I really appreciate the opportunity to speak to everyone today about the issues that are going on in commercial leasing during the pandemic. Obviously, today's presentation is really focused on strategies that small businesses can use during this time. And it mainly focuses on small businesses that are currently either landlords or tenants under existing lease arrangements. We can talk for a minute near the end about new leases during this time, but for the most part, we'll be talking about strategies that existing tenants and landlords can use to get through this pandemic together. Before we step into some of the specific legal issues in leases, we should take a minute to just go through the background of where we are today. And we've all been living through this situation together and have all been impacted by it. But I think it's really important to take a look at the specific orders that have been issued by the mayor and think about how those impact our businesses. On the left side of the screen, you'll see a map that shows the incidence of COVID-19 by ward in the District of Columbia. And I think it's, we've all seen the national maps, but I think it's interesting to see that COVID-19 has impacted different wards in the district in very disproportionate ways. And I think if you are operating a business within one of the wards that is impacted more highly, then some of the guidance that the mayor has put out would be even more important to follow on a regular basis. This map came out yesterday as part of a situational update provided by the government of the District of Columbia. And that's really a sign of how this presentation had to come together, because the updates are happening every day. I mean, and it's hard to keep track of exactly what's going on. But I think let's look at the specific orders that the mayor has put in place so far. Let's first look at the timeline that we've gone through so far. COVID-19 was characterized as a pandemic by the World Health Organization on March 11th. And on the very same day, Mayor Bowser issued a declaration of public emergency and public health emergency. It wasn't until 2 days later that the president declared a national emergency. And it wasn't long after that Mayor Bowser extended those initial orders on May 20th through April 24th. In a subsequent order issued on March 24th, so-called non-essential businesses were closed, and we'll get into the distinctions between essential and non-essential businesses in a second, and why that matters in a commercial leasing. And there was a prohibition on large gatherings. On March 30th, the stay-at-home order was issued through April 24th. And on April 15th, the orders were extended through May 15th. And so that's the current date that we have from the District of Columbia when these orders would expire. I think we'll get to an outlook section near the end of the presentation, but I think we have every reason to believe that those orders could either be extended, or if they're not extended, that different types of restrictions would go into place. So we've all heard of the terms essential and non-essential businesses, or we may have heard of those terms in the national news in different publications and with different focus on what exactly is an essential business, sometimes comically referring to golf as an essential business, or surfing in California as an essential business. And this is how the District of Columbia has broken down essential versus non-essential businesses. And so the first thing that I think any business in this time needs to do is to take a specific look at this order and figure out whether your business is considered essential by the District of Columbia or non-essential. And we won't have time during today's presentation to do that. But we can talk about some of the broad categories of essential businesses and some examples of non-essential businesses that were provided in the mayor's order. Essential businesses obviously include healthcare and public health operations, essential infrastructure, food and household products. But as you'll see, there are some exclusions to essential businesses. So you may be very familiar now that restaurants are not offering sit-down consumption. And the mayor's order specifically provides that restaurants and other facilities like food trucks can provide delivery, carry-out, or grab-and-go, but not sit-down consumption. And then the other categories are listed out here on the left side. you'll see, for example, in the financial services category, banks remain open during this time. Transportation and logistics, the construction sites remain open. And then another example of an exclusion is under the category of living facilities. The mayor's subsequent order put in place additional restrictions regarding the exclusion of visitors and screening requirements for living facilities in the District of Columbia. And so those are the categories of essential businesses on the left side of this slide. And the mayor doesn't really define what is a non-essential business. If your business is not considered essential, then it's a non-essential business by definition. But the mayor does provide some specific examples of businesses that are not considered essential. Those would include tour guides and touring services, gyms, health clubs, spas, and massage establishments, theaters, auditoriums, nightclubs, hair, nail, tanning salons, barbershops, and all the others that are listed on the right side of this slide. So the first order of business would be to figure out, go look at the mayor's order, figure out whether your business, if you haven't already done this, is essential or non-essential. And then just because if you figure out that you're an essential business, then you have to think about how do you need to operate during this time. Just because you're an essential business doesn't mean you can go about business as usual. The mayor does, the district does strongly encourage all essential businesses to remain open, but those essential businesses that remain open have to comply with what are referred to as the social distancing requirements. Those social distancing requirements include the requirement to maintain at least 6 feet of distance from other individuals, to wash your hands with soap and water for at least 20 seconds, covering coughs, and regular cleaning of high-touch surfaces, and the requirement to not shake hands. If you operate a business within a food sale, hotel, or transportation business, then there were some additional restrictions that the mayor put in place by a subsequent order that require the use of gloves and masks or mouth coverings, and you would need to go and look at the specific order to figure out how to comply with those requirements. In addition, essential businesses are required to take all reasonable steps necessary for employees to work remotely. So to the extent you're an essential business and some of the services that you provide can be provided remotely, the mayor's order requires you to take steps to do that. So that's how we need to operate as an essential business right now. What about non-essential businesses? The mayor's orders make clear that even if you're a non-essential business, that doesn't mean that you can't conduct any business. The restrictions on essential versus non-essential businesses, that distinction goes to on-site operations. So as a non-essential business, you can continue to conduct business, if possible, through telework operations. That's what I've been doing. I'm now in the 7th week of working from home. Or if you have a home-based business, you can continue to operate to the extent that you're not going to be in physical contact with someone else, and that you can conduct your business in compliance with those social distancing requirements we talked about. And even if you are a non-essential business, there are certain on-site operations that the mayor's orders permit. And those are called minimum basic operations. And it makes sense to look at these to figure out what are the things that you're allowed under the law right now to do, even if you're in that category of a non-essential business on site. So you're allowed to be on site. to perform minimum necessary activities to maintain the value of your inventory, to ensure security to process payroll and benefits. You're allowed to be on site to facilitate employees to work remotely. You are also allowed to be on site to provide cleaning and disinfection of your facilities and to provide employee supervision of contractors or employees that are providing essential maintenance of the facility. And I think since this is a presentation that covers commercial leasing, I think this last point is important, that even though there's a pandemic going on, if you're a tenant or a landlord, there may be maintenance that needs to occur on site, and the mayor's order does allow for you to perform that. So now that we have sort of a background of where we've been and where we are right now and the rules of the road in terms of how we're supposed to operate, let's look at some strategies that we can use in commercial leasing right now. And I think it's important to note that this presentation is really targeted toward small businesses and nonprofits in the District of Columbia. Some of the strategies that we'll talk about may not apply if you're a larger business. They may not apply if you are not operating in the district. This is really a DC-centric presentation for the small business community here. The first question that is on everyone's mind if they're a tenant under a lease right now is whether they're required to pay rent during a pandemic. So we're going to walk through some of the legal arguments that tenants have made and that landlords and tenants have been arguing about in terms of whether rent should be paid right now. First, I think going back to that definition of essential and non-essential that we just discussed, it's important to figure out whether you're an essential or a non-essential business right now, in my opinion, because not only is an essential business allowed to be open, the mayor has strongly encouraged those essential businesses to remain open. And although there may not be a legal argument under your lease to not pay rent, if you're in the essential category, then I would think that your argument in terms of asking for rent relief from your landlord would be a lot weaker if you are considered an essential business, because you're being strongly encouraged to remain open for on-site operations at this time. Now, if you're a non-essential business, then you can only perform those minimum basic services, minimum basic activities, and you may not be able to offer your regular business services, and you may have lost a significant amount of revenue as a result of the closure order. So in that case, you might have a stronger argument as a tenant that the landlord might want to work with you towards rent relief. The first provision that most tenants are looking at right now in their lease is called a force majeure provision in terms of trying to get relief from paying rent. And this is not the same force majeure provision that might be in your lease. And so you'd have to go and look at your actual lease and figure out whether the language in your lease applies. So what I've done here is just copy an excerpt of what I would think is a typical force majeure provision. And in most lease negotiations that I'm involved in, there is very little negotiation up until this pandemic of the force majeure provision. It was almost considered what's called boilerplate language. So no one really reviews it or negotiates it. It's just part of the lease. And a force majeure event is some type of event like a war, an act of God, or a casualty, something that happens that makes it impossible, something that's outside of your control that makes it impossible to perform under the lease. And you'll notice that in this particular provision, pandemic is not mentioned. But in many leases, pandemics are not mentioned. Pandemics may have been added after the SARS outbreak, but for the most part, most leases that I've seen do not specifically reference a pandemic as a force majeure event. However, the language that's drafted here has a catch-all phrase that includes in bold restrictive governmental laws or regulations, so like the mayor's order closing non-essential businesses, or at the end here, other reasons of a similar or dissimilar nature beyond the reasonable control of the party who delayed in performing work. So there could be other types of events that could occur, like a terrorist attack or something that may not be specifically listed here, that would still constitute a force majeure event. And in that case, the force majeure provision says that the party who's delayed in performance by that force majeure event, it's okay that you're excused for that period of delay. But you'll notice here at the bottom, and this is in most leases right now, and I actually reviewed a lease yesterday that was an older form of lease that did not have this. But in most cases, you're going to see an exclusion that basically says that the provisions, the force majeure provisions, will not operate to excuse the tenant from the prompt payment of the rent, and that delays or failures to perform from lack of funds will not be deemed delays beyond the reasonable control of a party. So you would need to check your specific lease language here, but in most cases, the force majeure provision most attorneys prior to the pandemic would say that it would not excuse payment of rent based on what's going on right now. Another question that tenants have asked is whether COVID-19 is considered a casualty. So they'll look to the casualty provisions of the lease. And yet, once again, I'm copying here an excerpt from a lease that's just an example, and you need to go to your specific lease to figure this out. But let's just read the first clause, which says that if the demised premises shall be damaged by fire or other casualty, and then at the bottom of this clause, there's a rent abatement provision. So rent would abate after a fire or other casualty. And I've italicized the word damaged because in most cases, attorneys are looking at this and they're realizing that a physical damage needs to have occurred for the rent abatement provisions in the casualty section of the lease to apply. And unfortunately, I don't think that it's a very good argument, potentially a very good argument, that COVID-19 would be considered a casualty that's causing a physical damage to the premises. So another clause that tenants have looked at is the service interruption clause. And here again, I'm copying just an example provision. And at the top of this slide is the language that you would find in most leases. And in most leases, if there's an interruption of services, and you'd specifically be looking for a reference to access to the premises, because that's what's been denied in this case. But you would want to look for a clause like this in your lease. But in most cases, there's this language that says that the landlord is not liable to the tenant for any damages based on that. And in some cases, tenants are able to negotiate for what's called a service interruption clause. And that's the bottom portion of this slide. And in that case, there's rent abatement that's offered if, as a result of these specific failures of services, then by the landlord, then rent abatement could occur. So if the landlord goes in and cuts off your electricity, and just does it out of spite for you, then there would be relief under this clause. And you have to read the specific language. In this case, the landlord put in a clause that said, but specifically excluding any condition resulting from fire, casualty, or force majeure. So if this landlord would probably have a pretty good argument that COVID-19 is not considered, is not an event that results in rent abatement under this service interruption clause, because not only is there a specific exclusion, the language doesn't talk about access to the premises, the electricity and other services may be available in your space. You've just been denied by the closure order from operating your on-site operations. So I've listed out some other arguments here, and I think we'll get to some more practical conversation in a minute, but I'll just take a moment to run through some of the other arguments that lawyers have made and landlords and tenants have been discussing. And those are, is this a temporary condemnation? Is COVID-19 basically like an eminent domain or a taking of a portion of the property? And that's, one argument that could be made. The arguments of frustration of purpose or impossibility of performance, the fact that the closure order has been put in place has created a situation where it's impossible for you to perform. It's frustrated the underlying purpose of your lease arrangement. And then we won't even get into the covenant of quiet enjoyment. I'm just putting these here as examples of some of the types of arguments that landlords and tenants have been making during this time. I think it's really important for you to go and look at your lease and try to figure out whether, look at some of these clauses and see, is there some type of out if you're a tenant? And as a landlord, you're going to look at clauses, you're going to look to see whether there's specific language requiring the tenant to pay rent, even though an order like this is in place. But I think it's important to realize that these are great legal arguments, but they may not provide you with any relief during this time as a practical matter. And so asserting lots of legal arguments against your landlord if you're a tenant or vice versa may not be the way to actually work towards a solution in this time. I think we may see cases in the courts that relate to these arguments, but I think we're going to see those mainly in terms of large businesses that have lots of cash and reserves and who are working with sophisticated lawyers to argue for something. If we're as small business owners, I think we really need to be more practical about how we can handle rent right now. And just to give you this is a national statistic. As of April 17th, about 51% of retail tenants had paid their April rent, compared with 85% who had paid their March rent. So this is a significant drop-off nationally in retail payment of rent by retail tenants. And I think that's an important point to make as well. If you're a retail tenant, that's where we're really seeing the most delinquency in rent. We're seeing it also in office leases to some extent, but if you are in an industrial lease, if you have a different kind of lease, it's much less likely that you would be impacted by the closure of non-essential business order. But given that high rate of delinquency, it's unrealistic for some landlords to strictly enforce their lease in this time, and in some cases it might be deemed not permitted by law. So landlords and tenants are really motivated at this time to come together and make a solution to get through the crisis together and to come out on the other side. If you're a small business landlord, then you want your tenants to be there, successful in paying rent to you. And as a small business tenant, you want to get through this time and you want to be able to operate your business in the future and maintain your lease. Since this is a presentation focused on DC small businesses, both landlords and tenants should be aware of the impact of the Translux Radio City Corporation case, which is a 1947 case. And this case, it means that as a tenant, if you don't pay rent, if you don't pay your rent, and the landlord goes and gets a judgment against you, then you have the right to pay that delinquent rent along with court costs, and it's called the Translux amount. And the judge would have to approve the late default interest, late charges, and other fees that are charged, similar fees that are charged under the lease. So even if you're unable to pay your rent right now because of a cash flow issue, it doesn't mean that as a commercial tenant that you're going to be evicted. There's this option to redeem your lease if later on you have the cash flow and you're able to make those rent payments. So since May 1 is tomorrow and rent is due tomorrow, this is a very timely presentation because tenants may be thinking through the question of whether they can make their rent payment right now. Many tenants missed the April rent payment, and there's concern among landlords that many tenants, many more, could miss their payment of rent tomorrow. There are liquidity and cash flow concerns on both the landlord and the tenant side right now. As a tenant, there's a loss of revenue from those on-site operations for non-essential businesses. And as a landlord, if your tenants are not paying rent, then you can't pay for expenses, taxes, insurance for the property, and you may have trouble paying the mortgage for your property. So there are cash flow concerns on both the landlord and the tenant side in this environment. There are also reputational risks of not paying your rent, and those risks, I think, mainly are risks that large, well-capitalized businesses or businesses that have an online sales component are bearing right now. So as a small business, I don't think the reputational risk is as great. In the industry term of mom and pop shop, I think that most landlords are not going to hold you to a reputational risk for not paying your rent now. But particularly larger businesses or the businesses that are still earning money during this time, there's been some backlash when large businesses haven't paid their rent. So I've copied a couple links here. In the first one, in Europe, the company in Germany, Adidas, did not pay their rent, and it became a social media phenomenon because people realized how successful Adidas had been in prior years and how they were making dividends to shareholders. And the CEO came out and actually issued a public apology for not paying rent and paid rent. And I don't think we've seen that as much here in the U.S., but there's another link to an article here. We're definitely seeing some landlords assemble what they are calling blacklists of tenants who seem to be potentially taking advantage of this situation. And rest assured, as a small business, you likely do not fit in that category. But if you do have the ability to pay rent, if you have an online component, if you are generating revenues, then paying your rent is certainly what's generally required under your lease during this time, most leases. I think we also need to consider, in terms of the decision of to pay or not pay rent, you have to consider the security involved. So if you personally guaranteed the payment of the rent under your lease, as a small business, then you need to realize that the landlord could have a personal remedy against you for not paying your rent. And then if you put up some type of security, either a letter of credit or a security deposit, then a landlord could apply against that letter of credit or security deposit. And then if it's a letter of credit, if they've applied against the letter of credit, then you not only have a problem with your landlord, you now have a problem with your bank. And I think we'll get into some arrangements that in the next slide that landlords and tenants are entering into to try to ease some of the pain during this time. But one of the strategies that I've heard of recently is if a tenant has posted a security deposit, then some landlords and tenants are entering into an agreement where the landlord will take and apply that security deposit right now towards the payment of rent during the pandemic, and then give the tenant an extended period of time to replenish that security deposit. So there's definitely all kinds of arrangements that are being worked out between landlords and tenants. And so I don't claim to have the universe of solutions on this slide, but I do think that these are the arrangements that I'm seeing most commonly. And those are called rent deferral and rent abatement agreements. So rent deferral is preferred by landlords because in the rent deferral scenario, a tenant has to pay that rent that's deferred back over a later amortization period. Whereas in a rent abatement scenario, that rent is never repaid. The duration of rent deferral that I'm generally seeing, I think in most cases, most commonly I'm seeing in this 2 to 3 month range for rent deferral. And this obviously depends on the circumstances of the landlord and the tenant. I've also seen up to 6 months referenced from a different source, although I've never entered into an agreement that's that long. Some tenants are trying on a rent deferral arrangement to base the duration of that deferral on the pandemic, how long that pandemic or stay-at-home order remains in effect. And as a landlord, you might be wary of that because you might want to cap the overall period because we don't know exactly how long those orders will remain in effect. As time has moved on, so if some tenants who struck a deal earlier on, I think had a larger deferral period than if you go to your landlord now and make a deal, because people are starting to already talk about returning to work. We'll get to the outlook section later on, but the deferral period may shrink as time goes on. But landlords are starting to hear about some type of re-ramp period. So the concern here is that maybe the order is lifted or maybe it's replaced with a less stringent order. And the tenant may be able to go back in and operate, but they might be struggling to make the same revenue that they made before. Just jumping to the rent abatement, I think in terms of duration, I think generally there could be a shorter duration involved if the landlord is providing you with rent abatement because it's not being deferred to being repaid over this later amortization period. In the deferral scenario, that amortization period might start July 1, it could start next year, and the period of amortization is something that you would need to negotiate with your landlord. And it could be 6 months, it could be a year, it just depends on the actual facts and circumstances involved. And then you also have to consider in terms of an agreement with your landlord, in terms of deferral, if you're a tenant, or abatement, whether that will be a full or partial deferral or abatement. So as we had just discussed, the landlord may have significant expenses right now that it needs to cover in terms of its mortgage, and they may be able to get a forbearance agreement themselves, but they may not. So in many cases, the deferral or abatements are not 100%. And if the tenant is able to offer to pay a lesser amount, 40, 60%, 50% of the payments that are otherwise due under the lease at this time, then the landlord might be more receptive to that. There's also a distinction, and we won't be able to get into it fully, between fixed rent and additional rent. And the additional rent are things that are like pass-throughs for common area maintenance or operating expenses, taxes, and insurance. And those are things that, as a landlord, you might want to ask the tenant to continue to pay during this time, because you're going to incur those expenses no matter what. And as a general rule, no interest is, I'm generally seeing no interest being charged on the deferred rent. It's just repaid over that later period of time. So as a tenant, you might want to ask for no interest being charged. And as a tenant, you might also want to ask for a waiver of any sort of late charges or default interest under the lease for not paying the rent on time. It's important in any agreement that you reach that it be a written amendment to the lease. So as a written amendment to the lease, you can't just call up your landlord and ask them for one of these agreements, strike up a deal, and then not put it in writing. It doesn't work that way for a commercial lease. And you can't do it in an email. It actually needs to be a formal amendment to the lease agreement. These agreements, in many cases, would be subject to the lender's consent. So if you're a landlord and you have a mortgage, then your loan documents likely require you to obtain consent before you give concessions on rent to tenants. So you need to look at those loan documents and make sure to figure out whether that's the case. And in many cases, I think we've seen that lenders are so overwhelmed with requests right now in terms of forbearance agreements and other issues that have been raised by the pandemic, that in many cases, they're not responsive when a landlord goes and tries to get consent to an individual lease amendment right now. So you may have to sign an amendment that's subject to that lender consent as a tenant. As a landlord, you may require a tenant to use stimulus funds or insurance proceeds that later become available to repay the landlord and offset any rent relief provided. And if you haven't paid your rent as a tenant, and you're going to your landlord and asking for some kind of relief, if you enter into an agreement, the landlord might condition entering into that amendment on you paying some portion of that delinquent rent or all of that delinquent rent. So obviously, again, this is not the full universe of deals. This is all over the map, and landlords and tenants are looking at specific circumstances and figuring out what works for them. But these are some of the agreements that are being entered into right now. I think it's also important to consider, and it's not listed here, but if you're a tenant and you're worried about that re-ramp period, then there could be a solution for you to offer a percentage rent deal during a re-ramp period. And I haven't seen it necessarily, but as a small business, you might be able to work with your landlord and figure out a solution to offer some type of percentage of gross sales instead of paying the rent that you used to pay under your lease for at least a period of time as you ramp back up.
Hey Ross, I'm just gonna, if I could just interrupt really quickly. I had an interesting question that I hadn't seen before. One of our attendees asked if it's fair or reasonable for the landlord to ask for you to maybe split the rent, you to maybe pay half of the rent over this time period. Is that something that either that you've seen or that it would be doable?
Yes, I've definitely seen that as an arrangement where if the tenant is paying half of the rent, I think that, obviously you have to go into this as a tenant and realize that your landlord may be feeling a lot of pain as well. And so sharing that burden somehow may be the way to get to a solution and work through it together. Many landlords don't purchase real estate with a cushion to not receive rent, and
Right.
and not getting rent right now could be a big issue for them. So if they're able to pay a portion of the rent, then maybe that could work as an agreement.
Okay, thanks.
So that's a great question. As you talk to your landlord, if you're a tenant, about this, I think it's really important to remember that communication is key. Landlords, in many cases, own multiple buildings, have many tenants who are not paying rent, and they're faced with the task right now of organizing that information, figuring out who's paid rent, who hasn't, how much cash they have on hand with respect to a particular building, and following up with all of their tenants to check to see what's going on if rent hasn't been paid. And I think it's key as a tenant, I think, if you're able to communicate at a higher level with your landlord, I think you're going to possibly get to a better arrangement with them, because I think what's frustrating some landlords the most is that there is a certain subset of tenants who have not paid rent and who will not respond at all to the landlord's requests. And I think in that case, the landlords are more likely to sort of ratchet things up, issue default notices, if only to bring you as a tenant to the table to negotiate, to figure out what's going to, how this is going to be resolved. As a landlord, you might want to ask a tenant to submit financial information like sales figures. If you're a tenant, then just being as proactive as you can be with this, I think, would be helpful. If you take a deep dive into your finances and you can show to your landlord how this situation has impacted your sales, then I think the landlord would be more willing to work with you to figure out a solution right now. I also see landlords and tenants bartering with other lease provisions. There could be a provision in your lease that the landlord really doesn't like for some reason, that they're willing to get to, if you were willing to give that up, then they'd be willing to enter into an agreement with you. Also, if you're a tenant and you're willing to extend your term at the end of the lease, then a landlord might be more willing to enter into an agreement with you right now. I think landlords are afraid in some ways that they're providing this relief and that a tenant could just come back basically and ask for more later because of the fears of an additional wave of the coronavirus, the idea that the closure order could come back at some point in time. And so as a landlord, you might want to put in a waiver provision to if you enter into one of these agreements, so that you know that this is all of the relief that you're providing. And then obviously, if it doesn't work out as a tenant, you might be able to come back and make another agreement with your landlord. But I think there's that concern on the landlord side that, when is it going to end? As a landlord, I think right now you would really want to be looking to your mortgage lender to try to get some type of relief yourself, a forbearance agreement. And if you get that forbearance relief, then to look to your tenant and try to pass that relief on to them in some way. I think landlords and tenants are looking at this situation different than defaults before, and I think everyone is trying to work together to get through this situation. And if a landlord is able to get a forbearance agreement with their lender and is able to pass that on to their tenant, then I think it's more likely that that landlord and tenant are going to have a stronger relationship after the crisis is over. I think as a tenant, you need to be aware that, you have certain basic obligations under your lease, even if you're not allowed to be on site for normal operations. And the DC orders allow you to be on site for that, for, security, for the supervising contractors. And I think it's important to stay on top of that to the extent it's safe and possible right now, so that you don't come back to your store and find that there's a greater problem than you realized. My practice doesn't focus mainly on bankruptcy, but I think it's important also to note here that bankruptcy courts have done something very unusual during the pandemic, and that's that they've approved non-payment for certain debtors that have closed stores like Pier 1. So as a landlord, you might have to keep that in mind, that if your tenant goes bankrupt, files for bankruptcy, then you may be faced with a situation where a court allows them to not pay rent during the pandemic. And so now that we've sort of worked through the legal issues, looking at your lease, some of the practical arrangements that landlords and tenants are working through together, I think it's important to take a moment before we turn to any other questions and talk about the outlook right now. And this is really evolving every day. And there was an additional update from the mayor's office yesterday that I reviewed as part of this presentation. And the focus has really turned in DC towards coronavirus testing, quarantine, and contact tracing. And on April 23rd, Mayor Bowser established the Contact Trace Force to hire hundreds of additional tracers at DC Health. At the time of on April 23rd, the mayor had confirmed that there were about 65 contact tracers at that time, and 70% of confirmed cases have been traced. And they were really looking to hire a lot more tracers, 200 tracers, up to an additional 700 tracers, whose jobs will be to mitigate that spread around DC through a 5-step process of testing, isolating, tracing, quarantine, and connecting to services. And this is something that I think has been in the news as something that's lacking in the U.S., but the mayor has really stepped up efforts here in D.C. to put that trace force in place to track the spread. In terms of what the financial markets have been, what analysts have been saying, I've copied here a link from an analyst, a chairman of market and investment strategy for JP Morgan. And in his view, the U.S. is about 2 weeks behind Europe. Though obviously we may not have the same level of tracing in place, and there could be just variation either, as far as the U.S. or D.C. is concerned, for that matter. We're starting to see, obviously, some U.S. states begin to loosen restrictions, though I think the latest guidance from D.C. really calls that into question, and we may see the restrictions continue beyond that May 15th date if we don't see the trends going down here in D.C. and we don't have that contact trace force in place. But if we do follow the trends that have been going on in Europe, those orders that are in place could be loosened before complete repeal. The social distancing requirements could remain in effect, such as the requirements, or in DC, maybe a strong recommendation to wear masks in public. And in addition, what's happened in Germany, Austria, other places, certain categories of stores have reopened first. And in some cases, smaller stores have been permitted to reopen before larger stores. And in some cases, there have been occupancy restrictions placed on stores. So all of that to say, the impact of coronavirus on commercial leasing will likely continue after that initial loosening of restrictions. If you're looking at entering into a new lease at this time, there's definitely more, there's more information than we can cover during today's presentation, and you would need to consider how coronavirus might impact the provisions that you're negotiating in your lease. I think it's important to end with adapting your business to what people are referring to as the new normal. So to the extent possible, innovating and finding solutions to offer your services to customers in different ways during this time, especially as we see restrictions possibly continuing for a longer period of time, is really the best thing that we can do right now. I hope that today's presentation really offers you some guidance in how to approach this issue of rent and other issues under your lease right now, and that you're able to work through this process, either if you're a landlord or a tenant, and you can come out on the other side stronger than before. And I appreciate everyone's time today, and I appreciate the opportunity to speak for the DC small business legal community. Darryl, do you have any other questions?
I do. Thanks so much, Ross. This has been really helpful and clear, and I will tell you, I'm already getting some texts offline singing your praises. So thank you for that. I do have a couple of questions. There is essentially in the vein of, I've gotten a few questions on this. Is there a way, if I'm a tenant, is there a way for me to find out if my landlord has received a forbearance from their bank, and what rights do I have to sort of seek my own forbearance or my own abatement or deferrals you were talking about?
So I think that's a good question. I'm not aware of any way to, as a tenant, to find out whether a landlord has received a forbearance agreement. So I don't know if there's, other than asking, or if it's reported in the news that certain banks are offering forbearance, then maybe you can find it out that way as a tenant. But I do think that approaching your landlord and realizing that that's an issue that they're facing, and structuring your discussion around it is helpful, because if they're unable to get a forbearance agreement, they may need you to pay some amount of rent during this time. But if they're getting a full forbearance, or they're only paying interest, then maybe you can negotiate as a tenant a better deal together to defer more rent, or to possibly abate rent during this time.
Okay, and then and I was also going to say there might be an opportunity. The problem is a lot of folks may not necessarily know, a lot of tenants may not know where their what sort of banking sort of relationship their landlord has, but a lot of the banks that we've been working with, on mortgage issues, have been sort of posting. You may not know if your landlord has received a forbearance, but you would at least have the opportunity to look to see, oh, I know they work with, they have a mortgage through, Bank of America, and I know that they're providing this kind of assistance. That might be a hope, hopefully that might be an entry point to your conversation about sort of negotiating with your landlord. I did have a couple more questions. One, are late fees allowed during this time period? Is that something that folks can have to worry about?
So I think I haven't seen in the commercial context anything saying that late fees are not permitted during this time. I think it's important to distinguish between the residential leasing laws and commercial leasing. And as far as I'm aware, I don't think that there can be late charges on residential leases right now for your apartment, but for a commercial lease, I think it's a different story.
Mm-hmm. Okay, let's see. So one question I'm just seeing now, are landlord demand letters, notices of default valid during this time? And another point to that question is, I know the DC courts are closed right now and evictions aren't happening right now. So, to that end, what would if somebody was having delinquency on paying rent, it's probably going to take a little bit of time before any sort of actual movement were to happen in the courts, but I always wanted your thoughts on that as well.
Right. No, that's definitely a consideration right now. And as a landlord, I think realizing that, the practical consideration about whether you can actually evict a tenant right now or after the pandemic because of what's happened, I think that has to weigh on a landlord's mind. And I think it's important to realize that different jurisdictions are going to handle this differently. And DC is a more tenant-friendly jurisdiction. So, for example, the Translux case about redemption, that doesn't apply in many places. There's just different options and avenues for tenants in DC that may not apply in other jurisdictions.
Okay. I think I've got one or two more questions. And I think this is probably may apply to a lot of folks. What's the case if what are the considerations if owners of the business, personally sign for their lease, or they sign in their personal capacity, or something to that effect? What potential considerations might somebody have?
Right, that's a great question. And as a small business owner, many small business owners are required to sign a personal guarantee of their lease by a landlord as security. And if the tenant doesn't pay rent, then the landlord can pursue a claim against the guarantor. So they could pursue payment of that rent directly against the guarantor.
Right, and while thankfully, none of that sort of litigation would be moving immediately, it's certainly something that, particularly the business owners who are on the call who have personal guarantees need to be thinking about as we move forward. So I think with that, I think we've hit on just about all the questions that we had. So first, I want to say thank you very much, Ross, for doing this. I'm going to ask the audience to virtually applaud while you probably can't hear this, but I am applauding you right now, Ross. Thank you so much for agreeing to do this, and you provided some really great information for the attendees. I just wanted to let all of you know we will be sending out a survey to all of our participants for you to share your thoughts. If you have, particularly if there anything additional information that you're looking for, any advice you're seeking. A couple more points to hit on. If you'd like to share this with your friends, this webinar is being recorded. You'll be able to find the slides and the audio recording at our resource site at www.lawhelp.org/DC/CED. During the registration for this webinar, a number of you expressed interest in one-on-one consultations regarding your commercial lease. We will reach out directly to those who made that note in their registration information. For those of you who did not make that note but have realized they may need additional sort of information, they can also go to that resource site and find information to get in touch with us, or you can always email cedinfo@dcbar.org. My hope is that we've answered those questions now, and that you aren't going to need any additional information. Again, I'd like to thank to Roscoe, thanks so much to Blank Rome and to our friends from the DC Small Business Development Center Network for partnering with us. Have a great day, everyone, and take care.